This isn't a joke. A judge just ordered a farmer to pay $61,000 because of a single emoji. No signed papers, no handshake, just a thumbs up emoji. And here's the terrifying part. This ruling just changed the rules for everyone who sends emojis, including you. This is how it all happened. Chapter 1. The beginning. It's March 2021 in Saskatchewan, Canada. Kent Mickleborough runs a grain buying business. He's been in the industry for years, working with local farmers to purchase crops like wheat, canola, and flax. One of those farmers is Chris Achter. They've done business together before. Multiple times, actually. Their relationship is professional, straightforward, built on years of successful transactions. Kent is looking to secure a contract for flax. The agricultural commodity market can be unpredictable, so locking in prices early is standard practice. He drafts up the terms. 87 tons of flax to be delivered in November at $14.59 per bushel. He takes a photo of the contract. He sends it to Chris via text message with a simple request. Please confirm flax contract. Now, this is how they've communicated before. Quick texts, efficient. In the farming industry, where everyone's busy and deals move fast, this kind of informal communication has become normal. No need for lengthy back and forth when you've worked together for years and trust has been established. Chris receives the message. He looks at the contract photo on his phone, and he replies with a single emoji. That's it. No words, no follow-up. No, yes, I agree, or looks good to me. Just a thumbs up. Kent sees this and thinks, perfect. We have a deal. He moves forward with confidence. He lines up buyers for the flax. He arranges logistics. He plans his business around this agreement. Everything is set for November delivery. Chris, on the other hand, goes about his business. In his mind, he simply acknowledged receiving the message. He saw the contract. He sent a thumbs up to let Kent know the message came through. Nothing more. He didn't think he was agreeing to anything. Two men, one emoji. Two completely different understandings of what just happened. And neither of them realizes they're heading toward a legal battle that will make headlines across the country. Chapter 2. The problem. Summer turns to fall. The agricultural market, as it often does, begins to shift. Flax prices start rising. Significantly, this happens sometimes in commodity trading. Weather conditions change, global demand fluctuates. Supply issues emerge. Prices that seemed reasonable in March can look very different by November. By the time November rolls around, the market price for flax is considerably higher than the $14.59 per bushel that Kent's contract offered. Chris, watching these prices climb, realizes something. If he's not bound by that March contract, he could sell his flax for much more money. We're talking thousands of dollars in additional profit. The delivery date arrives. Kent is waiting for his 87 tons of flax. Chris doesn't deliver. Not a single bushel. Nothing. Kent reaches out, probably expecting this is just a scheduling mix-up. Where's the flax we agreed on? Chris is genuinely confused. What are you talking about? I never agreed to that contract. Kent is stunned. He pulls up their text exchange on his phone. You sent me a thumbs up. Right here. That's an agreement. Chris shakes his head firmly. No. That just meant I received your message. I was acknowledging that I saw it. I never said I was signing anything. I never agreed to those terms. They go back and forth. The conversation gets heated. Neither man is budging. Kent believes with absolute certainty that he has a binding agreement. He's made business decisions based on this deal. He has buyers waiting. He's counting on this flax. Chris believes with equal certainty that there was never a deal in the first place. A thumbs up isn't a signature. It's not a contract. It's just an emoji people send dozens of times a day without any legal implications. The conversation goes nowhere productive. And because the stakes are high, because there's real money on the line, because neither side can convince the other, this dispute ends up exactly where you'd expect. In court, Chapter 3, Understanding Contract Law. Before we get to the trial, it's important to understand some basics about how contracts work. For a contract to be legally binding, you generally need a few key elements. First, there needs to be an offer. One party proposes specific terms. Second, there needs to be acceptance. The other party agrees to those terms. Third, there needs to be consideration. Both sides are exchanging something of value. And fourth, there needs to be intention. Both parties must intend to create a legal relationship. In traditional contract law, acceptance usually required some clear, unambiguous action. A signature, a verbal agreement, a handshake. Something that clearly indicated, yes, I agree to these terms. But here's the thing. The law has always evolved with technology. When telegrams became common in the 1800s, courts had to decide, can a contract be formed over telegraph? The answer was yes. When telephones became widespread, courts asked, can a verbal agreement over the phone be binding? Again, yes. When fax machines arrived, courts recognized faxed signatures as valid. When email became standard business communication, electronic agreements became enforceable. The law doesn't stand still. It adapts to how people actually communicate in the real world. And now, we're in the era of text messages and emojis. The question this case is asking is, has communication evolved to the point where an emoji can constitute contract acceptance? That's what the court has to decide. Chapter 4, The Case. When this case goes to trial, both sides present their arguments. Chris's position is simple, and honestly, pretty reasonable. I never signed a contract. A thumbs-up emoji isn't a signature. It's not a formal agreement. It's just a way of saying, okay, I saw this. People use thumbs-up emojis all the time, without meaning to legally bind themselves to anything. His lawyer emphasizes this point. In our modern digital world, we use emojis casually. They add tone to our messages. They're shortcuts for communication. They help convey emotion in text, but they're not meant to carry legal weight. Think about how many thumbs-up emojis get sent every single day. Millions, probably billions. If every thumbs-up created a binding contract, the legal system would collapse under the weight of lawsuits. Asking someone to pay $61,000 because of a cartoon ad on a screen seems absurd. It goes against everything we understand about how casual digital communication works. Chris's defense also points out that he never received the actual contract document. He just got a photo of it. He never had the chance to review it properly, to have his lawyer look at it, to consider the terms carefully. A thumbs up to a photo isn't the same as signing a physical document, or even clicking, I agree, on a digital form. Kent's side, however, tells a different story. His lawyers point to the history between these two men. This wasn't their first transaction. They'd worked together before, multiple times. And in those previous deals, Chris had responded to contract offers with brief text replies. Sometimes he'd say, looks good. Sometimes just, okay. Sometimes even shorter responses. And every time, he'd followed through on those deals. He'd delivered the grain. He'd honored the terms. Those brief text responses had always meant, yes, I accept. So this thumbs up? It's not random. It's not out of character. It's completely consistent with how Chris conducts business. Kent's lawyers argue that in the context of their business relationship, the thumbs up clearly meant, yes, I accept these terms. It wasn't just acknowledgement. It was agreement. They also point out that Kent's text message was very specific. He didn't just send a contract photo. He wrote, please confirm Flack's contract. Confirm. That's a clear request for agreement. And Chris responded with a thumbs up. What else could that possibly mean, except yes, I confirm? The court has to weigh these arguments carefully. Is a thumbs up just a casual acknowledgement, the way Chris claims? Or is it, in this specific situation, between these two specific people with this specific history, a clear acceptance of contract terms? Chapter 5. The Decision. June 2023. The ruling comes down. Justice Timothy Keene of the Court of King's Bench of Saskatchewan makes his decision. The thumbs up emoji, in this case, constitutes a valid acceptance of the contract. Chris Achter is ordered to pay Kent Mickleborough damages, totaling $61,442, plus legal costs and interest. The courtroom reaction is immediate. This is a landmark decision. Everyone knows it. The judge's reasoning is measured, careful, and deliberate. He acknowledges right away that this is new legal territory. Courts haven't dealt with many cases where emojis are treated as contract acceptance. This is uncharted waters. But he points out that the law has always adapted to new forms of communication. When fax machines became common, courts recognized faxed signatures. When email became standard, electronic agreements became valid. When people started using digital signatures, those were accepted too. Communication evolves. The law evolves with it. That's how it's always worked. Justice Keene writes in his decision, this court readily acknowledges that a thumbs-up emoji is a non-traditional means to sign a document, but nevertheless, under these circumstances, this was a valid way to convey the two purposes of a signature. Those two purposes? To identify the person agreeing and to demonstrate their acceptance of the terms. In this case, the judge looks at the context carefully. Chris and Kent had an established business relationship. They'd done deals before using informal text communication. Kent sent a contract with a specific request for confirmation. Chris responded with a thumbs up. A reasonable person, the judge concludes, would interpret that thumbs up as yes, I agree to these terms. The fact that Chris might have meant something different doesn't change the analysis. Contract law doesn't care what you secretly meant in your head. It cares about what a reasonable person would understand your communication to mean. And in that moment, with that context, a reasonable person would understand the thumbs up as acceptance. The judge also notes that Chris could have responded differently. He could have said received, will review. He could have said, got it, let me think about it. He could have said nothing at all. But he chose to respond with a thumbs up to a message, specifically asking him to confirm a contract. That matters. Chris has to pay. Chapter 6. The immediate reaction. The decision makes news immediately. Headlines spread across Canada and then internationally. Farmer ordered to pay $61,000 over thumbs up emoji. Court rules emoji can be legally binding contract. Your text messages just became a lot more dangerous. Legal experts are divided. Some praise the decision as a necessary evolution of contract law for the digital age. We can't pretend that business communication happens the same way it did 50 years ago. People make deals over text now. The law has to recognize that reality. Others are deeply concerned. They worry this opens the floodgates for misunderstandings to become lawsuits. They argue that emojis are inherently ambiguous and shouldn't carry legal weight. Business organizations start issuing warnings to their members. Be careful with your text communications. Your casual messages might be binding contracts. Law firms begin advising clients on digital communication best practices. And regular people start questioning every thumbs up they've ever sent. Did I just agree to something? Could this text come back to haunt me? The anxiety is real. Chapter 7. The Implications. This decision sends ripples far beyond Saskatchewan, far beyond Canada, even. Because here's the thing. This isn't just about one farmer and one grain buyer. This is about everyone. This ruling establishes a precedent. It says that emojis can, under certain circumstances, be legally binding. Your thumbs up isn't just a casual acknowledgement anymore. It can be evidence of agreement. That check mark you sent could mean you accepted terms. That handshake emoji might be a binding deal. That okay hand gesture could be interpreted as acceptance. Most people don't think about this when they're texting. They're just communicating quickly, casually, the way everyone does now. But the law doesn't care about your casual intentions. The law looks at what you said, or in this case what emoji you sent, and asks, what would a reasonable person think this means? And if a reasonable person would think you agreed to something, then legally, you might have agreed, even if that wasn't what you meant at all. Chapter 8. What you need to know. So what does this mean for your daily life? First, understand that context matters enormously. This farmer lost his case partly because of his history with the buyer. They'd done business before using brief text confirmations. There was an established pattern. If you don't have that kind of relationship or history, a thumbs up might not carry the same weight, but don't count on it. Second, pay attention to what you're responding to. If someone sends you a contract, a proposal, or any kind of formal offer, and specifically asks you to confirm or agree, your response matters. A thumbs up in that context could absolutely be interpreted as acceptance. If you're just acknowledging receipt of a message without agreeing to anything, say so explicitly. Got it. I'll review and get back to you by tomorrow. Received, we'll discuss with my team first. Thanks for sending. Let me look this over. Don't just send. Third, when money is involved, use words. Actual words. Emojis are fantastic for casual conversation. They're quick, they're expressive, they add personality to text. But when there are financial stakes, when you're discussing contracts or agreements or business deals, take the extra 10 seconds to type out an actual response. Because a thumbs up might seem harmless, until it costs you $61,000. Fourth, save your communications. If you're doing any kind of business over text, keep those messages. Screenshot important conversations. Save them somewhere safe. Because if a dispute arises, those messages become evidence. You want to be able to show exactly what was said and when. Chapter 9. The bigger picture. This case reveals something important about the world we're living in now. Digital communication has become so normal, so integrated into every aspect of our lives, that we've stopped thinking about it as documentation. But it is. Your text messages aren't just conversations. They're permanent records. Your emojis aren't just fun little symbols. They can be interpreted as legal statements. We've gotten so comfortable communicating casually through our phones that we've forgotten there might be consequences. But the law is catching up. Courts around the world are starting to recognize that binding agreements don't require formal signatures anymore. Other countries are watching. Other courts will face similar questions. Can a thumbs up be a contract in the United States? In the UK? In Australia? We don't know yet. But this Canadian case just gave them a roadmap. Chapter 10. The lesson. Chris Achter probably sent hundreds, maybe thousands of thumbs up emojis in his life. Most of them meant nothing. Your digital communication matters now in ways it didn't before. The casual thumbs up you send to your boss when they ask if you can work the weekend, that might be a binding commitment. The checkmark you send to your landlord when they propose a rent increase, that could be acceptance. The handshake emoji you send to a client discussing project terms, that might be a contract. So the next time you're about to send a quick emoji in response to something important, pause for a second. Ask yourself, could this be interpreted as agreement? Could this create obligations I'm not prepared to meet? Could this come back to haunt me? Because in 2023, a Canadian court decided that it absolutely could. This case is real. The people are real. The money is real. And the precedent it set is now part of legal history. A thumbs up emoji can be a contract. Not always. Not in every situation. But under the right circumstances, with the right context, with the right history between parties, it absolutely can. And now you know? So be careful out there. Because the internet just got a whole lot more legally binding. And that little thumbs up you're about to send, it might mean more than you think. A lot more. If this story shocked you, if it made you think twice about how you use emojis, do me a favor. Hit that like button. Subscribe to the channel. Because I'm breaking down more emoji stories like this every week. Stories about how these tiny symbols are changing our lives in ways you never expected. And trust me, this thumbs up case, it's just the beginning. See you in the next one.